Hello, everyone, and welcome to Uncivil Law. For today's case by request, it is an old U.S. Supreme Court, 1798 old U.S. Supreme Court. This is Caldeira versus Bull. This case deals with what is ex post facto and what is merely retroactive, and if those are different things. So the legislature of Connecticut did a thing to overrule a court, change the law, did some retroactive stuff. Is that constitutional? Is it not constitutional? What is the Supreme Court's rule? Let's get started with this. The legislature of Connecticut in 1795 passed a law which, for reasons that are detailed, set aside a decree from the court of probate for Hartford, so a will. So the court that does wills is a probate court. So the probate court was interpreting a will. It issued an order, and the legislature said, "We don't think so." So the court said they disapproved of this particular will and refused to record the will and granted a new hearing with the court with liberty to appeal in state ends. So they disagreed with a disapproval of a will for whatever reasons, refused to set aside and set in a new hearing of the probate court in 6 months. So the legislature of Connecticut has acted to overturn a court decision in a particular case involving a particular individual with whether or not their will is active or not, and has said, well, we disagree with the court and we're going to overrule it legislatively, and we're going to say that there's a new will, here's the new thing in the new hearing. So is that the kind of thing that Connecticut can do? Well, let's find out. The Supreme Court of Connecticut had absolutely no problem with any of this, however, and said that there was no error. So the Supreme Court of Connecticut said, we're fine. Okay, great. So then the plaintiffs who say, this not so much, the resolution of this law from the legislature of Connecticut in this case is an ex post facto law, which is prohibited by the United States Constitution or by any federal government or any state federal government. Contrary to the Constitution, is void. And this court has the power to declare it void. So they say, well, no, that's not fair. This is an ex post facto law. The legislature is trying to legislatively overturn the finding of the court with respect to a particular thing that's already happened in the past. And they're trying to go backwards in time. They can't do that. Or can they? Then the court says, it appears to me a self-evident fact that several state legislatures retain the power to legislate, designated to them by their state constitutions, and that especially where they are not expressly taken away by the Constitution of the United States. So he believes in federalism. He says federalism is a thing, and the legislatures have the power to legislate, unless, of course, the federal Constitution says they can't. The establishing courts of justice, the appointment of the judges, and making the regulations for those judges within each state, according to its laws, are subjects not entrusted to the federal government. So who should be judges? What are the regulations for those judges? How do they come to be? Not issues for the federal government. And it appears to be the exclusive province and duty of the state legislature. This is not a thing for the federal government to get involved with. State issue, talk to the state Supreme Court, talk to the state legislature. Don't talk to us. This is not our province. By the existing law of Connecticut, a right to recover property had been vested in Caldeira and his wife in consequence of a decision of a court of justice. But in virtue of the resolution of law, no, not so much, and that decision, the right to recover certain property was divested. No, not so much for you. And the right to that property declared to be instead in Bull and his wife. So the court said, this goes to Caldeira. And the legislature said, no, we think it goes to Bull. And so now you have the legislature overturning a specific decision of a specific court and granting legislative remedy in a court case. So the sole inquiry is whether the resolution of that law in Connecticut having this operation is ex post facto within the meaning of the Constitution. So yeah, the legislature has specifically overturned a specific decision from the court and said that was the wrong decision. We are legislatively going to say, no, the court said this people get the money. We're divesting them, which is a fancy way of saying we're taking the money and we're giving it to these other people. And the question is that an ex post facto law? Let's discuss more. The legislature of the states may enjoin, permit, forbid, and punish They may declare new crimes and establish rules of conduct for its citizen in future cases. They may command what is right and prohibit what is wrong, but they cannot change the innocent into guilt or punish innocence as a crime, or violate the right of an antecedent lawful private contract or the right of private property. The Constitution of the United States prohibits the legislature of the United States from passing any ex post facto law, and in Section 10 lays authority on the legislations of the several states, and among them, no state shall pass any ex post facto law. I shall describe what is an ex post facto law within the meaning of the term of the Constitution. The prohibition, no state shall pass any ex post facto law, necessarily requires some explanation. For by itself, on its own terms, without any explanation, it is unintelligible, and it means nothing. So, yeah, what is an ex post facto law? By itself, it doesn't tell you anything. Literally, it is only that a law should not pass concerning, after the fact, a thing done or an act committed. I would ask, what fact, of what nature, of what kind, and by whom? So, like many things in the Constitution, this was not something that was just invented out of nowhere. This was something that was established in English law before. So the words by their own terms say, well, you shouldn't do anything backward looking. But then the question is, in what respects or in what domains, in what set of circumstances? So what is this thing talking about? And fortunately, the answer to this, like many questions, can be found in the where it came from, the English law. So what is specifically an ex post facto law? The prohibition in its letter is not to pass any law concerning after the fact. But so it is not that it deals with any law after the fact, but rather the plain and obvious meaning and intention of the prohibition is instead this. So it is not dealing with all laws that concern the past. Rather, it is dealing with this specific inquiry. The legislatures of the several states shall not pass laws after the fact done by a subject or citizen, which shall have relation to such fact, and shall punish him for having done it. So you can't punish people for things they did in the past. You can't retroactively punish. The prohibition considered in this light is a prevention in favor of security of the person, to prevent that person from punishment by legislation. So the legislature can't punish a person through a legislative act that has a retroactive application. You can't go backwards in time. You can go forwards in time, but not backwards. And he then says he does not think that this clause was inserted to secure citizens in private rights of either property or contracts. So he says, looking to the English law and how this term came to be and what exactly it's talking about, this is a criminal law concept. It is only dealing with the criminal law. It is only designed to prevent legislatures from punishing people by legislation. So you can't pass a law declaring someone to be guilty. That's called a bill of attainder, which is also prohibited by the Constitution. So you can't pass a law that says this person is guilty of this crime. That's a bill of attainder. That's illegal. And you can't also pass a thing that says, well, okay, we're not going to pass a law that says you're guilty. We're just going to change what the law was in the past. So now that you're guilty of it. Can't do that either. That's ex post facto. So you can't make someone guilty by legislation, and you can't retroactively change what crimes were at the time by legislation. That is what is prohibited. I will thus state what I consider to be the ex post facto laws within the meaning of the Constitution. First, every law that makes an action done before the passing of that law, and which at the time was innocent when it was done, criminal, and punishes that action. So you can't pass a law that was innocent at the time and then make it criminal in the past and then punish you for it. No. Every law that aggravates a crime or makes it greater than when it was committed. So we can't make it worse retroactively. No. Every law that changes the punishment and inflicts a greater punishment than the law that existed when the crime was committed. So we can't make the punishment worse retroactively. Every law that alters the legal rules of evidence and receives less or different testimony than the law required at the time of the commission of offense in order to convict the offender. So we can't change the burden of proof or burden of production retroactively. All these and similar laws are manifestly unjust and prohibitive. In my opinion, the true distinction between the ex post facto law and those that are merely retroactive, which are not prohibited. Every ex post facto law must necessarily be retrospective, but every retrospective law, that is to say laws that act backwards, are not necessarily ex post facto. Only the former, the ex post facto, are prohibitive, not those that are retroactive. However, I do not consider any law to be ex post facto within the meaning of the Constitution when that law mollifies the rigor of the criminal law, makes it less severe. Only those that create or aggravate the crime, or increase punishment, or change the rules of evidence for the purpose of conviction. So if the legislature wants to make things less criminal retroactive, that's totally cool. They can't make things more criminal, but they can make things less criminal. So a legislature can retroactively make things not crimes if they want to. Without answering the question as to whether this court has jurisdiction to decide whether a law made by Congress, contrary to the Constitution, is void, because we haven't gone to Marbury versus Madison. That's how old school we are. So we're definitely not going to try to figure that out today. That's for a different day, trying to figure out whether the U.S. Supreme Court can void a law by Congress. I, however, am satisfied that the U.S. Supreme Court does not have jurisdiction to determine the law of any state legislature, and this is the critical part, contrary to the Constitution of that state, is void. So the state of Connecticut is master of its own law. So one of the things that the parties said is this is unconstitutional under our state law. And the state Supreme Court said, no, it's not. This is not a violation of our law. And so the Supreme Court says, well, I don't know what to tell you. The state Supreme Court is master of its law. So the U.S., whether or not we can strike down a federal statute, we haven't figured that out yet. We're not going to figure that out for a little bit. But we definitely can't strike down anything that's a state law. We can't strike down state laws. We can't say they're unconstitutional under a state constitution. That is just not our domain. If it's state law, talk to the state Supreme Court. Don't talk to us. I therefore think the courts of Connecticut are the proper tribunals to decide whether the laws, contrary to its constitution, are void. Connecticut can figure out that, and if they say no, it's not, then no, it's not, and it's not our problem. In the present case, they have, both in the inferior and superior state Supreme Court, determined that the law in question was not contrary to the state or federal law. So this is not a violation of the state constitution as far as the state Supreme Court is concerned, and the state Supreme Court is master of its law, and it is not our problem. So go talk to someone else, not our issue. Thus, that brings us to the end of the discussion of Caldeer versus Bull, a very interesting early U.S. Supreme Court that deals with Supreme Court jurisdiction, and one that is perhaps relevant today dealing with election issues as to whether or not the U.S. Supreme Court can change anything dealing with state issues on the state law, because the election law is principally one of the state legislatures, and the Supreme Court here in this 1798 case says, state law is an issue for state courts. So will the Supreme Court continue to do that relating to elections? I guess we'll see, but this case would suggest that whatever the Pennsylvania Supreme Court decides, for example, is the correct interpretation of Pennsylvania law, and the Supreme Court has no jurisdiction to overhear that. Will that change? We'll find out, but for the moment at least, that's the end of the discussion of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.